Good morning. Hey, good morning. Cody Brackett.
Morning, Judge.
Good morning, sir. How can I help?
I'm here for a PCC for Miss Jasmine Bowser.
Bowser, okay.
Yes, Judge. And actually, could I have a brief breakout room with Miss Bowser before we go on the record?
Go ahead and join the breakout room.
Thank you.
Ms. Gregg, good morning.
Hi, Judge. Good morning.
Good morning. What can I do for you today?
Yes, I have a probable cause conference for Mr. White. He's in custody. My co-counsel is Mr. Tuttles, and there's a special assignment prosecutor, Brian Johnson.
Mr. Johnson is here.
Thank you, Your Honor.
Yes. Darnell White. Darnell here. Did you send over an appearance, Ms. Colbert-Gray?
Yes, Your Honor, I filed an electronic appearance with the 36th District Court on February the 14th, Your Honor.
Okay.
Thank you.
Calling case number 2305-549101, people of the state of Michigan versus Darnell White Jr. Defendant is charged with count 1, homicide, murder, first degree, premeditated. Count 2, assault with intent to murder. Count 3 and 4, weapons, stolen, and firearms.
Appearances for the record, please.
Good morning, Your Honor, to your staff. This is Brian Johnson for the people, P84143.
And good morning, Your Honor. May it please this honorable court, Sina Cobra Gray appearing on behalf of Mr. White, who is in fact in custody, P52354. No objection to appearing via Zoom.
All right, what's your pleasure?
Oh, Judge, I apologize. I have a co-counsel. Mr. Tuttles is also representing Mr. White as co-counsel, and I'm not sure if he has appeared as of yet, Judge.
I just brought him out the waiting room. Mr. Tuttles?
Yes,
There he is. Okay, I just called White. Your appearance for the record, please.
good morning, Your Honor. May it please this honorable court, Antonio D. Tuttles, on behalf of my client, that's Mr. Darnell White, who is physically not in your courtroom at this time. He should be, Mr. White should be on Zoom, or he might be there physically because he was in custody.
All right. What's your pleasure, counsels?
Your Honor, today, I'm sorry. Go ahead, Mr. Johnson.
Yeah, I believe that Mr. Tuttles and Ms. Gray Cobra Gray would like to set this for a preliminary exam.
Judge, I can speak on that. Your Honor, we're respectfully requesting a preliminary exam. However, I have been in contact and communication as early as this morning with Mr. Johnson. Judge, there is quite a bit of outstanding discovery that Mr. Johnson has indicated that he will provide to both Mr. Tuttles and I. I am merely in possession of the investigator's report. And after reviewing the investigator's report, there's quite a bit of discovery that's outstanding, including the medical examiner's report, 911 calls, photographs, labs reports. We're not in possession of any witness statements and or police reports, search warrants, or medical records. And Mr. Johnson is very aware of that, and he has made communication with my office and will provide that as soon as it is in his possession, Judge. Additionally, he has emailed over an order of protection for discovery materials. I have absolutely no objection. I will sign that and get that back to him this morning.
All right, so we're looking at an exam date of March 14th. What time of day is best for you?
Your Honor, I possibly may have a trial that week. The defense is asking for an adjournment, and I'm not sure if the judge is going to grant it or not. Can we do the 21st by any chance?
Judge, I apologize. I've got a 3-bagger homicide starting with Lisa Lindsay on the 20th. That's going to take me through the rest of the month. I am available the entire week of the 13th.
The 13th of March. How about the 16th? And I concur totally with my co-counsel. I have literally 13, 14 pages of discovery on the homicide case, and that cannot be. So I had asked my clerk this morning, is this all of that they seemed over?
All right. The court is available March 16th. I'm
Ms.
definitely
White.
not going to put this out until April.
Ms. White, what time are you available on the 16th?
I am available on the 16th.
I can do the 16th, Your Honor. If I'm in trial, I'll make other arrangements, but we'll make it happen.
Does afternoon work better for you, Mr. Johnson?
Yes, it does, Your Honor. Thank you.
Let's do March 16th at 1:30.
Judge, thank you so much. And I will communicate with the court regarding discovery if there are any outstanding issues well in advance of the 16th.
Okay, great. Thank you very much.
Thank you, Your Honor.
Judge. Thank you, Judge. We appreciate you.
Thank you, Ms. Colbert.
Thank you.
Thank you.
Adam Woolbach.
Good morning, Your Honor.
Good morning, sir. What can I do for you? You're here on
I
the
have-
flag?
I have flags for PCC. I can waive his appearance, Judge, if that's okay.
Let me call the case.
I'm sorry?
Let me call it.
Calling case number 2305-560201, people of the state of Michigan versus Michael Clegg. Defendant is charged in count 1, domestic violence, third offense. Defendant has a habitual offender, fourth offense notice.
Appearances for the record, please.
Good morning, Your Honor. Patricia Manderdank for the people, P84088.
And good morning, Your Honor. Adam Molak, P number 55741, appearing on behalf of Mr. Cleggs. Is not present, Judge. We'd ask you to waive his presence.
For the waive the defendant's presence, what's your pleasure?
Your Honor, I have paper discovery. I just don't have any digital. I'd ask for a 1 or 2 week adjournment. Or the 9th, whatever works for the court.
Is there a possibility that this may resolve itself short of an exam?
I don't believe so.
Then we need to set an exam today then.
Okay.
And people, you're gonna get discovery to Mr. Woolbach when?
I can get it over today, Your Honor.
Okay.
I just needed to know who defense counsel was.
All right, great. Court will continue the plea of not guilty and set this matter for preliminary examination on how is March 8th at 12:30.
That's a bad day, Your Honor. 9th or the 10th available?
March 10th at 12:30.
That would be fine for the defense.
Thank you, Your Honor.
12:30, bond be continued.
Thank you, Your Honor.
Mr. Cohen.
Good morning, Your Honor.
Good morning, sir. What can I do for you?
Well, I think we may need to wait. I'm waiting on a client, Mr. Gerio Wadsworth from the county jail.
Okay, I just brought the county in.
Okay.
Let's see if they have Mr. Wadsworth. Good morning, Wayne County Jail.
Good morning, Your Honor.
Do you have a Mr. Wadsworth for me?
Yes,
Can I have Mr. Wadsworth, please?
yes, sir. It's Mr.
Thank you.
Wadsworth. They want you first. That don't work. Hey, Scott, you taking this water? Yeah. That's Mr. Wadsworth, Your Honor.
All right, thank you. We're ready.
They're right here.
She,
How are we doing? Is it possible for me to talk to my lawyer?
Hold on a minute, sir.
Judge Queen.
Yes.
calling case number 2206-040701, people of the state of Michigan versus Gerio Wadsworth. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, home invasion, first degree. Count 3, weapons, dangerous weapons, using self-defense break box. Count 4, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Patricia Manderdank for the people, P84088.
Is it
Good
possible?
morning, Your Honor. Just one sec, Mr. Wadsworth. I'll ask for a breakout room. This is Jonathan Cohen from Neighborhood Defender Service, P86151, appearing by Zoom with Mr. Wadsworth, who's also present by Zoom from the county jail. Mr. Wadsworth, can you just state your name, please?
Gerio Wadsworth.
All right. And Judge, I know I did want to ask the court to address bond this morning, and would it be possible to do a quick breakout room with Mr. Wadsworth before we address those issues?
Go ahead and join the breakout room.
Yeah, click that blue button. Do it. There you go.
All right, Mr. Bradford.
Morning, Judge. I am ready on Ms. Bowser.
Okay. I'll call Ms. Bowser.
Calling case number 2305-56030. People of the state of Michigan versus Jasmine Bowser. Defendant is charged in count 1. This is destruction of building, 1,000 or less than 20,000. Count 2, domestic violence.
Appearance, record, please.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Good morning, Judge, to and your staff. Cody Bradford with NDS Detroit, P85944. I have the pleasure of representing Ms. Jasmine Bowser, who is present via Zoom and consents to Zoom proceedings this morning.
Ms. Bowser, tell us your name.
Jasmine Bowser.
Who's your co-counsel there?
I'm Deontay Calloway.
Good morning, Ms. Calloway. What's your pleasure, Mr. Bradford?
Yes, Judge. We still need digital discovery in this case. I do have paper discovery. I would also ask the prosecution if there is an offer at this time.
I'm sorry, you're asking.
Offers at the exam stage.
I'm sorry, Judge.
Highly unusual to have an offer at the exam stage.
Yes, the only reason I was asking is because I know you typically ask if this can be resolved short of an exam. If there's no offer, we probably do need an exam track.
Yeah, what I normally mean by that is there a possibility it may waive?
Oh, okay, I understand. I don't have an answer to that question until I get the digital discovery, Judge.
So there is a possibility.
Possibly, yes.
So you like another PCC date?
Yes, please.
Court will continue to plead not guilty and adjourn the probable cause conference to House March 6th at 8:30.
March 6th, that should be fine with defense, Judge.
Thank you, Your Honor.
March 6th at 8:30. Donald, we continue.
Thank you.
Mr. Harris. Wyatt Harris. He's gone.
Yeah, Judge, here I am.
Good morning, Mr. Harris. What can I do for you? You here
Good
on
morning.
Scott?
Yeah, I have Scott. We're going to ask for an exam. Mr. Scott is in the Michigan Department of Corrections, but I'm going to ask for an exam, Your Honor. We did not have that matter resolved with his other matters.
Okay, let me call it.
Calling case number 2105-74-1101. People of the state of Michigan versus Cohen Scott. Defendant is charged in count 1, home invasion, first degree. Count 2, domestic violence, third offense notice. Defendant has a habitual offender, fourth offense notice.
Appearances for the record, please.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Good morning, Your Honor. Wyatt Harris, P54891, on behalf of Cohen Scott, who I know is in the Michigan Department of Corrections.
So we're going to discovery. He's going to send discovery on the case, but we can go ahead and schedule for an exam.
And I would be asking for a preliminary exam. It was my background on my other Zoom that I'm on, Your Honor. I'm sorry.
Okay. All right, the court will continue to plea of not guilty and set this matter for preliminary examination. I guess you're going to need approximately 2 weeks out to writ the defendant in the DOC. Is that right?
Probably, Your Honor. I heard you have a March 8th date available. Is that too soon?
That may be too soon.
Okay.
How about March 15th at 10 o'clock?
Well, I have a murder exam a murder trial that starts on the 13th. I'm not 100% sure it's going to go though.
That'll probably take you all of that week.
Well, yes, I put it this way, I would know by the 27th whether we're going to go to trial or not on that murder case.
Can you do March 10th?
I can do March 10th, Judge. Yes.
All right, let's do March 10th at so March 10th at 1:30?
That would be fine, Your Honor.
All right. We continue.
Thank you, Your Honor.
Thank you.
Yes, sir. Can I help you, Mr. Kermis?
Yeah, I'm here for a court date.
Are you the defendant?
Yes, sir.
You're not on my docket, Mr. Kermis.
I have a arraignment that says to join your Zoom. That's for the 23rd of today for an arraignment.
Does it have the judge's name on it?
Where would I find it? I'm sorry. Jones K, it says.
That's 435, right? Okay, let me give you the correct Zoom number.
Okay,
Let me know when you're ready.
I'm ready.
360-435-0000. Zero,
360-435-40.
Yes, sir.
Okay, thank you.
Oh. Galaxy 8.
Just make this current. Yeah, because the courtroom's not changed.
Thank you so much. Which Anderson is that we're missing? Joyce Coates. Yes, ma'am. Can I help you?
I've been trying to get in the courtroom, but I've been going to the wrong courtroom.
I have some bad news for you. You're still in the wrong courtroom. Are you a defendant?
Yes. say Jones K.
Yeah, that's Judge Kenyatta Stafford Jones. Let me give you the right courtroom Zoom number. You ready?
Yes.
360-435-0000.
Okay, thank you.
All right.
Oh my.
Mr. Cohen,
Yes, sir.
I forgot all about you.
All right.
Waiting on Mr. Wadsworth, right?
Yeah, thank you.
Okay, we're back on the record on case number 22060407701, People versus Gerio Wadsworth. Appearances for the record, please.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing by Zoom with Mr. Wadsworth, who's also present by Zoom from the county jail.
Tell me your name, sir.
Gerio Wadsworth.
What's your pleasure, Mr. Cohen?
Your Honor, I do have a motion for discovery that I emailed to the court, and I've CC'd Ms. Mandernack this morning. We just, we don't have digital discovery in this matter, and I would like to try and get a hold of that before the preliminary examination. So I did include an order for the court if the court is willing to issue an order for any outstanding discovery.
I signed it.
Okay, thank you. And then I think we're ready to set the preliminary examination. The only thing I wanted to ask with respect to bond is if the court would consider removing the tether in this case. I did see that bond was modified on the 21st to a personal bond, $25,000 with a GPS tether. But in this particular case, I'd just be asking the court to consider waiving the tether requirement, given at least my understanding of Mr. Wadsworth's lack of serious criminal record and lack of failure to appear history. And he does not live with the complainant in this case. They do have a child in common, but he will not have any contact with her while this case is pending. He's staying with his cousin
On the other side of town.
in Detroit on Ewald Circle. Thank you.
And I got 4 more on the way.
Okay, how is March 8th, 12:30?
It's on the way down.
I'm sorry, Judge, you said March 8th?
March 8th at 12:30.
Gotta find where he's at in the building.
Yes, that is good for a preliminary examination.
All right, March 8th at 12:30. Ms. Mandernack, as to bond.
As to bond, Your Honor, I would request that the tether requirement remain in place. In this case, the allegation, I believe that the tether in this case is necessary to protect the complaining witness, especially since it sounds like defendant is getting out on a PR bond. In this case, the allegations are that defendant came to complaining witness's house. She told him to leave several times, and he eventually entered the home by kicking down the screen door, grabbing complaining witness by the throat, and strangling her to the point that she couldn't breathe. So I believe that a tether is more than appropriate here to protect the safety of the complaining witness.
And Your Honor, if I could just add one detail about the allegations in the case. I think from the investigative report, it's clear that the complainant actually pepper sprayed Mr. Wadsworth in the face while he was outside the home. Allegedly, he was there just trying to see his daughter, and she pepper sprayed him because he wouldn't leave. But in any event, the rest of the, the rest of the allegations are what they are. Thank you.
I'm not exactly sure what's going on here, but the defendant has been given a personal bond. I'm going to err on the side of caution and keep the tether intact in place.
Thank you, Your Honor.
Of the community, particularly the complaining witnesses. So finally, we continue. Thank you.
Thank you, Your Honor. All right, Mr. Wadsworth, I'll be in touch soon about your other issue. Thank you. Have a good day, everyone.
Good day, right here. We have March 8th at 12:30. You're all set, Mr. Wadsworth. Connect your audio, ma'am. Connect your audio, ma'am.
Hello, can you hear me?
Not you, sir. You're all set.
All right. Oh, that's it? I can go?
Yes.
Thank you.
What's your name, sir?
William Bryant.
Hey, we're just waiting on your attorney, Mr. Bryant.
Okay, no problem. Will I get a moment to speak with him?
Yes, sir. Unmute yourself, ma'am. Yes, ma'am. Can I help you?
I was trying to log into a case for Darnell White.
And who are you?
I'm sorry,
Who are you?
his auntie.
Okay, so we've already Mr. White's case today, but when you do these matters, you have to go on YouTube to watch it. Mr. White's next court date is March 16th at 1:30 for preliminary examination.
Okay.
Okay?
All right, thank you.
You have to watch by YouTube where it's being live streamed, okay?
Oh, okay. All right, thank you.
All right, have a good day.
You too.
Mr. Anderson, since he's in the object.
Yeah, two, the last two. I was just letting know our prisoners are downstairs, the last two.
Detention call.
Okay. Okay, thank you. I appreciate it. I'll do that.
We don't need the first one. That's the second. You see Mr. Anderson? Yeah.
Nope. Mr. Anderson. What's your name, sir? Wayne County Jail. Unmute yourself.
Tell me your name. My name is Michael Plagues.
Okay, Mr. Cleggs, we did your case already. Your next court date is March 10th at 12:30. Ms. Lambert.
March 10th at 12:30. I got some questions to ask you, sir. You say March 10th at 12:30?
12:30.
12:30, sir.
One second here. Could you say that again, sir?
It's March 10th at 12:30.
So where would that be at?
It's going to be in 36th District Court, sir.
Okay, now, I got a couple of questions to ask you. I know they gave me the tether with the house arrest, but I done had 3 prior strokes within the last 6 months. I also done had 3 cardio visions on my heart where I had to go to the doctor to see my heart doctor. I have to go to the doctor to see my primary doctor. I have to go to therapy, and I have to go to the foot doctor. But here's the thing though, they took my truck on the 14th of this month, and it's been in impound. Is it any way possible I can get my truck to get around? I stay in Macomb County, and it's hard for me to walk around without my cane and my walker. In the house, I walk with a cane. Outside the house, I walk with a walker. So is that possible I can try to retrieve my truck? So I'll be able to get back and forth?
Possible to do what?
To get my truck out of pound. You gotta talk that loud. Oh, so I get my truck out of pound. So I can try to have a way to get back and forth. I live in Macomb County. And it's gonna be kind of hard for me to be trying to catch the bus, walk to the bus stop.
More concerned about getting yourself out before you get your truck. Because you can't drive your truck if you're still in jail.
That's true. And I was gonna try to call the towing company when I leave here today or tomorrow and try to see how much it is so I can try to get my truck to the house so I get it fixed, because the keys was threw down the sewage, and also the gears was threw down in gear. So I have my mechanic trying to fix it for me. That way I won't be late, missing no court days or anything. So is that possible that you could help me out with that?
What do you want me to do?
Huh?
What is it you want me to do?
No, what I'm saying is, since I'm on a house arrest, and they said the only thing I could do is go to go to the doctors, and then back home. I need to try to have my brother-in-law take me to find out where my truck is at. They said it's in 3 different places, my Elliott, Grinnell's, and on Grand River. And I don't live in Detroit. I live in Macomb County.
But if you're on house arrest, you're gonna be driving anywhere. Oh, you're talking about to your appointments.
To my appointment. Yes, sir.
What kind of way?
Okay, so I'm showing that you have a personal bond. I'm not even sure why you're still in jail right now. I'm not even showing that you have a tether.
Okay. Yeah, because the officer had said that I'll probably be leaving today.
Okay.
So you say you're not sure that I have a tether, I just have a personal bond?
That's what my records show.
Okay, so how much is that personal bond?
Personal bond means you don't have to post anything.
But how much is it though, the bond?
Nothing.
Oh, okay. So what?
Reduced to 10% personal. Omit is 10. That's not what I'm saying. That the numbers that they sent to the jail.
Okay, so I stand corrected. You do have a tether. You probably need to talk to your attorney, sir.
So when will I be able to do that?
That's up to you and your attorney.
I don't even have his number. I know his name is Adam Wolak, but I don't have no type of number, no type of way of getting in touch with him. Would the court provide me his information so I can call him?
We're looking now.
Say it again, sir.
We're looking now.
I can't really understand you.
We are looking now.
Okay.
313.
Hold on. 313.
310.
310.
98.
98.
98.
59.
So that's 313-310-9859. Am I correct?
He is correct.
Yes.
So you say call him and speak to him about trying to get some kind of way, try to get my truck out of towing.
Yeah, tell what your concerns are, sir.
Make sure what?
Tell your attorney what your concerns are.
Oh, okay.
Alexandria Spencer.
He says it's expensive.
No, sir, you're all set. Thank you. Have a good day.
All right, thank you. All right, Mr. Bryant.
Alexandria Spencer. Yes, ma'am. Can I help you?
I was here for my cousin court hearing.
Who's your cousin?
Galen Spencer.
Looks like you're in the wrong courtroom.
Okay, thank you.
But you have to view it on YouTube where it's being live streamed, whatever courtroom you're supposed to go to.
Okay, thank you.
Okay. Okay.
Well, yeah, I've been getting the bus before I even got here on all my accounts. So I guess this, this next. That's how I would request the person before we. Okay. After that, no, get out to that. I don't have no pain. Yeah. Excuse me, Your Honor.
Yes, sir.
Is there any other lawyer that could fill in for this process?
Your attorney is having some issues because he lost power. So he's been in communication with the court. He's been trying to log on. I'm not sure what happened to him. So he's coming in person. You in a rush?
Well, not really, but I am supposed to be getting a teller today.
Okay. Trying to wait around with Mr. Anderson. There he is.
No, Your Honor, I checked the virtual courtroom, a couple of other judges, and I'm getting the same problem.
All right. So your client is joining us from the Wayne County Jail.
Oh, yes, that's why I have a disconnected phone.
It's Mr. Bryant.
Yes.
We're ready on Bryant.
Good morning, Mr. Bryant. My name is Gary Anderson.
Hey, how you doing, Mr. Williams?
Anderson. Gary Anderson is his name.
Oh, sorry. How you doing, Mr. Anderson?
Good morning, sir.
Calling case number 2305-559901. People of the state of Michigan versus William Bryant. Defendant is charged in count 1, assault with a dangerous weapon, count 2, domestic violence. Defendant has a habitual offender work offense notice.
Appearances for the record, please. You're on mute, Ms. Vanderneck. I can't hear you for some reason. Go ahead and give me your appearance, Mr. Anderson.
Your Honor, Gary Anderson, on behalf of Mr. Bryant, P27210.
Tell me your name, sir. Tell me your name for the record.
William James Bryant.
What's your
Your Honor, at this point in time, based upon the nature of the charges, I request a preliminary examination.
All right. Court will continue to plea of not guilty and set this matter for preliminary exam. Sir, are you just waiting on a tether?
Yes, sir.
Okay, so you should be out soon. Court will continue to plea of not guilty and set this matter for preliminary exam. We'll set it for House March 8th at 9:15.
That works for defendant, Your Honor.
Thank you, Your Honor.
Okay, why don't we continue?
That was March 8th, right?
Yes, sir.
Thank you.
Thank you, Judge. Have a good one.
Excuse me, I thought I was supposed to get a packet, a discovery packet or something.
I did receive that yesterday afternoon, I believe. So, Mr. Bryant, please call me when you. The number I have on the affidavit is not correct. It says the number is no longer in service. Do you have a pencil and paper? Write down my phone number.
Oh, excuse me, can I get a pencil and paper? Hold on, the deputy is getting me one. Yeah, I unfortunately, my phone is disconnected right now.
How's your attorney gonna get in touch with you, sir?
As soon as I'm released, I'm already prepared to pick up another phone.
Okay, sir. Are you able to write my number down?
Yeah, the deputy is going to he's getting a pencil and paper for me as we speak.
Okay, thank you, sir.
Thank you, man. Appreciate it. Okay, what is it, sir?
248-302-7090.
248-202-7090.
Yes, sir. My name is Gary Anderson.
Gary Anderson.
Yes. So give me a call, okay?
As soon as I'm released.
Thank you, sir.
All right, thank you.
Good to see you.
Thank you, Your Honor. Your Honor, does anybody else have, obviously not have the problem I have this morning? I get a generic pay waiting room that just says you've reached the 36 District Court virtual rate.
And you went to 360-234?
40, yeah. But nobody else apparently has that problem.
No, I haven't had an issue this morning with anyone.
Thank you.
All right. Down to 11:30.
Use our phone to call in. That's what happened.
I do that all the time. Still shouldn't do that. No. See you guys at 11:30.
Excuse me, Your Honor.
It's gone.
Madam Clerk, that's all we had.
Okay,
All right, have a good one.
all right, you too.
Oh, there it is. Downtown, so we.
What's that?
Power.
It's on.
continue prosecuting it.
You know who it is?
Who, Ms. Cooper?
Oh, I didn't see it when I came to meet you.
Connect your audio. How about yourself?
I don't know how this happened for Monday.
She is here, she's in the case.
And Miss Cooper is here, she's in the witness.
There's one civilian, one witness.
Okay. Yeah, Ms. Cooper. Ema Unisoro. How bad did I tell your name? Yeah. Calling case 2260871, people of the state of Michigan versus Anita Etakudo Unisoro. Defendants charged with count 1 homicide, murder, second degree. Count 2 carrying a concealed weapon. Count 3 felony firearm. Appearances for the record, please.
Good morning, Judge Leslie Cooper on behalf of People, P3085.
Your Honor, good morning, and may it please the court. My name is Adam Clements, P number 77233, appearing on behalf of the defendant. Sir, state your name for the record, please.
There's date time set for preliminary examination. Are we ready to proceed?
We are, Judge, this in 1 second, set up the computer.
Time's up.
Now, 2 witnesses, include video and photographs, sir.
Okay. Any preliminary matters before we begin with witnesses?
Yes, Judge, just preliminarily, what I want to indicate is I believe that Madam Prosecutor has provided me with all the discovery that she has, and I'm prepared to go forward with preliminary examination today. But I did want to state on the record that I had an opportunity to meet with the officer in charge in this particular case with another witness before the case was signed. And there were still photographs that were presented to us during that meeting, which would suggest to us that there's more video evidence than what has been provided. I just want to make sure that I request on the record specifically that the defense is requesting all of the video that was extracted from the Truth nightclub from November 27, 2022. Now, I get that for the purpose of the preliminary examination, some things are pertinent, some things aren't, but I believe that the defense is entitled to all of the video evidence that the government has in their possession.
All of the video evidence has been provided. The stills that we're being seen today are taken from those videos we've already had possession of, as well as
Some of those videos, some of those stills were also provided separately as part of the discovery. So there's nothing outstanding that I'm aware of. There could be a stray police report or something like that that we don't have yet, but other than that, everything we have has been provided.
So again, to be clear, there's over 40 camera angles at this particular venue. I've been given 4 channels of video.
I'm sorry. Please switch to the microphone.
There's over 40 channels of video at this location. I've been given 4 channels.
Do we know that the police confiscated all 40?
Yes,
angles?
they took the entire DVR system.
Okay.
So, and then on top of that, Detective Mays, throughout the course of this very diligent investigation, I watched all the interviews of witnesses that were investigated at the DPD headquarters, and they're being shown still photographs from images from video angles that I don't have included in this evidence.com now. So I guess from my perception is if the government takes possession of the DVR for purposes of copying, then they're responsible for giving me all of the video evidence. Now, whether Ms. Cooper has it or doesn't have it, that's I can't say what she did or didn't get. I'm saying she certainly probably did provide me everything she has. I'm saying that we know for a fact that there's significantly more video than what was given to me.
Have you gotten this detective names?
I would, yeah, I've spoken with them numerous.
All right, so discovery is ongoing, so you guys can cross that bridge when you come to it. Right now, we're ready to proceed.
Yeah, Judge. Before we get started with witnesses, I would like to proceed with the medical examiner's report. This would be People's Proposed Exhibit Number 1. It is a Macomb County, Michigan Office of the Medical Examiner report. It is a report of diagnosis and autopsy on Stephen McWilliams-Dix, and there is a medical file number. There is a summary and opinion that reads as follows. Final diagnostic. Gunshot wound of back, perforation of the thoracic spine, thoracic aorta, small intestinal mesentery, and liver. Bullet recovered from right chest wall. Cause of death, gunshot wound of back. Manner of death, homicide. It is signed by Daniel J. Spitz, MD, and he's the Chief Medical Examiner of Macomb County. It was signed on February 3rd, 2023. I move for the admission of People's Proposed Exhibit 1.
Any objection?
No.
Admitted?
Secondarily, Judge, I would ask for stipulation that the body of Stephen J.B.I. McWilliams-Dix was identified by Tanya Dix, the mother of Mr. Williams-Dix, and that was done in the presence of Jennifer Diaz, representative of the Medical Examiner's Office in Macomb County.
I trust you're gonna have a report available.
Yeah, right here.
So stipulated for exam purposes. Court proceeds by stipulation.
Thank you, Judge. We will call Eric Latimer as our first witness.
Good morning, sir. Please step forward, give your name and spelling to the young lady that's seated over there. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat in the witness box next to me. Pull that door open, have a seat, and the microphone is to your left. You can either pull it down to your mouth or you can hold it right up to your mouth and speak into that voice. You can hold it.
You can grab the whole thing. There you go.
Maybe when you're ready.
State your name for the record, please, sir.
Eric Latimer.
And Mr. Latimer, I'm going to draw your attention to November 27th of 2022. Do you recall that date?
Yes.
And were you at a location at 6200 East 8 Mile Road?
Yes.
What is that location?
It's a strip club.
Okay, and does it have a
Speaking to
name?
the microphone, please. This is a strip club.
You can hold that microphone up. Okay, and where, I'm sorry, and what's the name of the strip club?
Truth.
Truth, is that Truth Gentlemen's Club?
Truth Gentlemen's Club.
Is that City of Detroit, County of Wayne?
Yes, I believe so.
Okay, and what was your association with that location?
Security guard.
Okay, how long had you been working as a security guard at that location?
Off and on for probably 5 years.
Okay. Did there come a time that evening where something happened inside the bar?
Yes.
What happened inside the bar?
As I was standing on one end of the stage, there were altercation. I noticed the altercation going on down on the other end of the stage. So as I walked across the stage, I saw one of the gentlemen hit another gentleman across the head with a champagne bottle.
Okay. Do you know those people? Okay, which was the person that you knew? I'm sorry?
Augie.
Augie? Is that person seated here in the courtroom? You can stand up if you need to, sir.
Yeah.
Okay, could you say what he's wearing and where he's seated?
White and green shirt, and seated to the right.
Okay. Indicating for the record, Anyama Udasoro, Judge?
So noted.
Thank you. You indicated that you saw him. What was his role in that particular altercation?
I'm not sure as I approached, I just saw the gentleman hit him across the head with the bottle. He stepped back. I shoved the gentleman that hit him in the head with the bottle with my left hand, and I jumped down and approached him.
Okay. There's a lot to unpack there, so let me give you bit by bit. So, the person you said seated here in the courtroom, Mr. Udisoro, is the person who got hit with the bottle. Is that right?
Yes,
Did he have any injuries that you saw?
I didn't approach him.
Okay. So you were approaching the person who had swung the bottle at you.
Exactly.
Okay. And did you know that person?
No.
Had you seen him before? What did he look like on that evening?
So what did he look like?
Yeah.
He was a tall gentleman. I believe he had dreads or braids or something like that.
Do you remember what color he was wearing at all?
No.
Okay. Did you have any words with that person?
No.
Okay. Did you shove him onto the bar? What happened next?
As I approached the gentleman before I can get up to him and have any words, he noticed another gentleman, he grabbed another bottle and tried to attack someone else.
And did that happen or not?
No, another security guard approached and knocked the bottle out of his hand, and that's when everything went outside.
Okay, so tell me what happened after the second incident. What happened next?
The gentleman that he was trying to attack with the second bottle ran outside to everybody else was first.
Okay, could you tell us what that person, the second person to be attacked, what that person looked like, what they were wearing?
No, I just know he had on some bright colors. I don't know exactly what he was wearing, but it was a bright color, orange or red or something like that.
Okay, and did he run outside the bar?
Yes,
Okay, did you go outside the bar as well?
yes,
And was that a large crowd that evening?
yes.
Okay, where did the people inside the bar go when these altercations were taking place?
I'm not sure. I ran up behind the people that, having one station. A lot of people stayed in, they didn't notice it, so.
Okay, and what time of the evening was this when this occurred?
I don't know, it was probably like 1 o'clock in the morning, something.
Okay, so at sometime after midnight?
Yes.
Okay. So you went outside, you told us you went outside, is that correct? Okay, you and a bunch of other folks?
Yes.
Okay, and how were you dressed that evening?
Um,
All black,
Yes.
as you're wearing today?
Yes.
Okay.
Security. Well,
Did you have your glasses on on that occasion?
yes,
Okay. And you looked as you do now, bald headed?
yes.
Okay. When you got outside, tell us what you saw next.
Everybody was just, running everywhere. I noticed, Augie and the gentleman was face to face, the guy swung and hit Augie in the face.
Okay, stop right there. Which gentleman is that swung him in the face?
The phrase.
Okay, is that the
The same guy that hit me with the bottle.
Okay, so earlier he hit him with the bottle inside the bar. I'm sorry, Judge. Outside the bar, you said, did he hit him with something or just his fist?
Yes.
Fist? What happened immediately after he hit him with his fist?
I'm not sure. My focus went towards the 8 Mile area. So as I said, I'm swinging, my focus went towards 8 Mile. I don't know if something was going on back there or not, but after that, I just heard a shot and took cover.
Okay, you heard a shot? And did you feel anything go past you?
Yes, I felt something go past my head and hit the door, so I didn't.
Okay, and you said you took cover. How did you do that?
I took a few steps inside the door because I was very close to the door, so I took about 3 or 4 steps in. Turned around, draw my gun, and started looking for a shooter.
Did you ever see who was the shooter?
No.
Did you ever see Augie any further that evening?
No.
Okay. And did you ever see what happened to the person that had hit Augie?
No, it was chest to chest with another security guard, and that's when they go back outside because that security guard back was turned to the parking lot, and there was a shooter out there. So I was walking up there to cover his back, and as they were talking, the guy just after a few minutes he started opening his shirt up, saying, "I'm hit, I'm hit."
Okay, so that was the person that had hit Augie was saying, I'm hit, I'm hit?
Yes.
Okay, and that's the same person that you had seen earlier in the bar, is that correct? May I approach him? I've given you, sir, what's for people's proposed exhibit number 3, and is that a photographs?
Yes,
Are those photographs that you have seen before, sir?
yes,
And did you in fact put your initials on those photographs?
yes,
What date did you do that?
the 28th.
28th of November,
Yeah.
2022? Yes?
Yes,
Okay. Looking at that first page, what do you see in that first page?
only just standing there.
Okay, and is that the person you identified during the courtroom?
Yes,
Could you flip the page to the second page, sir? And identify again what you see in that photo?
yes, only just standing looking around.
Is that inside the bar or outside?
Inside.
Okay. Page number 3. That's okay. Take your time. So tell us what that is, please.
Only standing outside the bar.
Okay, that's outside the bar?
Outside the bar.
Okay, and is he wearing the same clothes as he was wearing inside the bar?
Yes.
Okay, let's go to page number 4. Tell us what that is, please.
Well, it looks as if, the guy swinging, he was checking in the jaw.
Okay, and that's what you did, so that's what you saw as well?
Yes.
That fairly inaccurately represents what you perceived that evening, correct?
Right.
Okay. Is there another photo on that page or no?
No.
Okay, so go on to page 5. What do you see in that photograph that you identified?
Only firing a weapon.
That's Augie firing a weapon? Is there a gun in Augie's hand in that photo?
Yes.
And there are 2 photos on that page?
Yes.
And what is in the bottom photo?
He and another security guard, and I guess the guy that was shot, the guys with the red eyes.
Okay,
Objectionist, I guess.
so
I'm sorry, what did you say?
Objectionist, I guess.
we don't want you to guess. We just want to tell you what you recognize in that photo. So you don't know the 4th
I
person,
don't
right?
know the fourth person.
But
I know the fifth person.
you're identifying yourself, is that right?
Yes,
And did you write on that photo to identify who was who?
yes.
Okay, what did you write?
Shaq to the left of me. Augie in the photo and Big.
Okay, and Shaq is another security guard, am I correct?
Yes.
Okay. Thank you. I move for the admission of the photographs, People's Exhibit 3.
Any objection?
No.
Could you pass those to the judge, please, so we can see? Did you have any other connection with this incident, sir?
No.
Okay. Did you at any time find a casing?
Yes.
Okay, what did you do with that casing?
We were standing around and I noticed the basement on the ground. For some reason I picked it up.
Okay, did you ever turn that over to the police?
No, actually, the police hadn't got there. I think there's been one copy there or something like that. But no, I just put it in a napkin and I held on to it for probably about 20-30 minutes.
Whatever happened to it?
I mentioned to one of the other security guards that I was tired of holding this shell. I didn't know I was holding it for. And she, said, put it in this envelope. Well, not envelope, it was a blunt package. And she put it in there and she put it in a person that.
Okay, do you know who that person was that took the casing from you?
It was another security guard.
Okay, do you know that person's name?
Yeah, it's, I can't recall right now.
Okay, at any rate, you didn't have anything else to do with that casing?
No, I didn't know.
Where did you pick it up from?
Right at the doorway where I was standing. Outside.
Yeah, right at the doorway where you heard the shot or some other place?
Where I guess where the shot was at, yes.
Okay, no further questions, thank you.
Cross examine?
Yes, please. Good afternoon, sir. I'm gonna ask you some questions. If I speak too fast or I ask you a question you don't understand, just let me know. I'll try to ask you a better question, okay? All right. Now, you indicated that you were working in a security capacity on that particular night in question, is that correct?
Yes.
Okay. You, in addition to being present at the scene when the police arrived, you also went to headquarters and met with detectives, is that correct?
Yes.
Okay. And at that particular time, you identified members of security that you could see, right? They showed you some photographs, is that fair? Okay. And you also indicated that there were certain security members that were present that you know to be members of the mob, is that correct?
Yes.
Okay. Can you tell the court what you mean by the mob?
The mob is their security, now their security company.
Okay, so they're a company within the company, is that fair to say? I can break it down differently if I don't want to confuse you. So there are members, at least 3, that work in a mob that do security, correct?
The security team is called.
Okay. And they also work at Truth Nightclub, correct?
Yes.
Okay, are you aware of whether or not those individuals also do private security for a rapper that was there that particular evening as well?
They do private security. I'm not sure if they was one of that particular rapper.
Okay. Now, during the particular day, where were you stationed from a security perspective at the start of At the start of the night?
I was actually standing on the stairway of the stage before it all happened.
Was there a well-known rapper that arrived to your knowledge, that arrived to the strip club at that particular evening?
Yes.
Okay, do you know approximately what time that was?
No, they normally come like 12, 1 o'clock.
Okay. On that particular day, would you agree with me that the Truth Nightclub, that there's a main entrance where normal patrons would come in through?
Yes.
Okay, and then in the rear, there's also a private entrance for high-level customers. Is that fair to say?
Yes, that's sometimes.
Okay. And the individual that was shot in this particular case, who you identified in that particular photograph, do you know which entrance he came in on that particular day?
No.
Do you know whether or not that individual had private security? When I say that individual, I'm talking about the individual who was shot.
Yes.
Okay. He had private security, is that correct?
Yes.
Okay. That private security guard that was with him was armed, is that correct?
Yes.
Okay. And when you and your fellow colleagues do security, do you normally allow
I'm
individuals?
sorry, I'm not sure if you are inside the club.
Okay.
Because no, you're not allowing private security to come in with weapons.
Okay. Do you recall, you had an opportunity to meet with this gentleman here, is that correct?
Yes.
Okay. Do you recall him showing you some photographs of the interior of the strip club on the night in question, the night of the shooting?
Yes.
Okay. Do you recall seeing an individual wearing a black ski mask that had a gun inside of the club, standing next to the decedent?
Private security.
Yeah, so when you say you don't know whether or not he had a gun inside the club, did Detective Mays show you a picture of a private security individual standing with the decedent with a gun in his hand?
That's it.
Was there a security camera to your knowledge of the private security interest in the rear?
Yes.
Okay. Do you know whether or not that camera was on and working on the night in question?
Not sure.
Okay. And you would agree with me that from your perspective, when you're working security, you don't allow individuals who are not a part of the staff to bring firearms into the strip club, is that correct?
Yes.
Now, you were shown one photograph of my client that you identified, is that correct? Yes. Okay. Had you known him prior to this particular event taking place?
I mean, yes, he does security with us. He used to do security with us. I don't know.
Okay, so it wasn't like you look at this photograph and that's what draws you. Remember, you knew this person, is that correct?
Yes.
Okay. How many people were with the decedent, to your knowledge? With the individual that got shot, the decedent, do you know how many people were with him? After he struck my client with the champagne bottle, what happened next?
I shoved him with my left hand.
When you say him, who are you referring to? Okay.
Shoved him with my left hand away from all these, and I jumped in between them and I approached the deceased. And as I was approaching him, he he grabbed another bottle and went out or something.
Would it be fair to say that there was a chase that took place at some particular point in time after my client instructed the champagne bottle?
Yes, the guy was chasing another guy.
Okay.
With the champagne.
Okay. And when you say another guy, you're referring to someone else outside of the event, is that correct?
Yes.
Okay. They run outside of the strip club towards the front, the main front entrance, correct?
Yes.
And then you're standing at the main front entrance, is that correct?
No, I came out behind them. I was inside the car.
During a particular point in time of the shooting, you're standing right
At some
there.
point, yes, I stood outside the party.
Okay, and that's almost, well, how much time transpires when my client was hit with the champagne bottle until individuals started running outside the club?
Within seconds, minutes, or something like that.
So this is a continuous situation. It's not like a break in time. My client is hit with the champagne bottle, individuals begin running out of the strip club. Is that correct?
Not right at that point, no.
That's why I'm asking you how much time.
Right, once he was hit with the champagne bottle, no one was running outside the club at that point. When I jumped down in between them, within a matter of seconds before I approached the deceased, he reached out for another champagne bottle and he attacked another gentleman up on the top. I ran after him.
So this would then be the second person that he's attacked at that
He was trying
point.
to attack the second person, but another security guard hit the bottle out of his hand as he was trying to attack him.
So after both of these attacks that were essentially, well, one attack was successful and the other one was stopped, is that fair to say?
Yeah.
Okay, then afterwards, that's when individuals start running outside of the club, correct? And would you agree with me that members of the security staff also chased that individual and pointed guns at him as he was running outside of the strip club?
I didn't see that.
Okay. Again, after you vacated the strip club, you stood at the entrance area, correct?
Yes.
The still photograph, and Ms. Cooper admitted that you identified names. That's your writing underneath where you're standing.
Yes.
Is that correct?
Yes.
Okay. Would you agree with me that there's an object in the decedent's left hand in the picture that the package of photos that you looked at?
Deceased left hand?
Yes.
I've never noticed how.
Are you able to look at the screen, sir?
Yeah.
Now, you'd agree that these are this is the same package of photographs. You've seen these before, right? The same package of photographs that was just admitted into evidence by the prosecutor. Is that fair to say?
Yes, he showed me.
Okay. And I'm asking you to focus in on what would be to the right if you're looking, but if you're where the decedent is standing, would you agree with me that there appears to be an object in his left hand?
I mean, it could be, I'm not sure. It could be something that's left hand, it could be something laying off the ground. I'm not sure. I'm not sure.
Okay. I'm gonna ask you to take a look at it. You recognize, may I approach that?
You may.
You recognize that this is a still photograph, correct? So when you say glaring off the ground, you're saying that potentially what you're saying in
I think he's gonna have to answer, but he's already said that he did not see anything in the person's hand. So I'm not sure why we're getting that horse. He's already answered that question.
first, that wasn't his answer. He said he wasn't sure, and he said it may have been a glare, which is why I want to make sure that he can see.
No, I'm saying that, yes, I can see that clear.
Right, sorry,
I'm not sure if something was saying.
Excuse me, I know what you said, I'm just clarifying, what the prosecutor said, what you said, which is not correct. And I continue this. So, does this help you testify clearly as to what you believe this is?
Judge, objection. Yeah, he's already testified. He's made it clear he did not know, does not know. He said he didn't know. What else do we have to hear?
Well, what you can do is let me do my cross.
Well, that's fine.
So this doesn't help you testify more, but thank you. You know an individual by the name of B. Rich?
Yes,
Okay, who is B. Rich?
he's a security guard.
Do you know whether or not B. Rich was armed on that particular night? You said you don't?
No, some security guards carry, some doesn't.
Okay. I'm gonna ask you to take a look at the screen. Can you tell the court, where this is?
Parking lot.
Okay, and you testified that this was, November the 27th, is that correct?
Yes.
Okay, does this appear to be a fair and accurate depiction of what you saw outside on a particular night in this area on November 27th, 2022?
What I recall.
Yes. At this time, Judge, I move for the admission of defense exhibit A, which will be channel 23 of the surveillance footage.
Any objection?
No.
And then,
Again, if I know you were in glasses, so I want to make sure that this is easy for you. I'm sorry? Is it easier for you to look at the TV screen or do you need me to bring in the Okay, all right. Are you able to tell the court who this individual is?
what individual?
Where the mouse cursor is? The mouse cursor is right here.
You have to do a picture of something.
You're not able to tell from looking at that? All right, that's fine. Now, you testified also previously that there was an individual wearing orange or light colored clothing that you saw was the second individual who was almost struck with a champagne bottle. Is that correct?
Yeah.
You testified that that individual was running outside of the club. Is that correct?
Yeah, he made, yes.
All right. Do you know, are you able to, looking at this video, to tell who this individual is?
Here.
Okay. Do you know an individual by the name of Bear?
It looks, yeah, I was about to say it looks like her.
Okay, and Bear was working on that particular night, is that correct? He's a member of the mob, is that correct?
Yes.
Okay, thank you. Do you see the decedent in this particular video frame?
No.
You don't recognize this is the person who was ultimately shot?
No, I can't, I'm not from here.
Okay, that's fair. Judge, this is, I've already moved for this to be admitted, is that correct?
You did.
Great. I can stop this. Now, is your testimony that you didn't actually see a shooting, is that correct?
Correct.
You simply heard a shot?
Correct.
Okay. Judge, may I retrieve the exhibit, so
Yes.
You said from what you saw, you weren't able to tell whether my client had an injury or anything noticeable in his face after being struck with a champagne bottle?
I didn't know this.
Did you ever look at his face to see, or that this wasn't a point?
Once I jumped down, I got glanced at him. He was probably 5 or 6 feet away. And I pursued after the other one.
Do you know who was working at the back security entrance on that particular evening?
There's no certain security that works back there. We do have people come to the back. We call, they call certain security guards to go back there and search.
So these individuals, when you say they call them to go back there and search, it's when the security team gets notice that individuals are coming to the rear entrance, correct?
Yes.
And then once the security team gets notice that these individuals are coming, then that's when the security will go back to check them to allow them to come inside. Is that fair? Okay. Now, there was a well-known rapper that was hosting a party there on that particular day. Is that correct?
Yes.
And you're aware of that, right?
Yes.
Okay. And when that happens, there's additional security that's requested. Is that fair to say?
There, I guess so. I'm only saying for us.
Yes. Right.
Yes.
So to ensure safety.
Yes.
Right? And on this particular night, are you aware of whether any rival gangs that were hacked to nightclub that particular evening?
No, I'm not sure.
So you weren't aware?
No.
Was there any point in time when you saw the defendant demonstrate any aggressive behavior inside of the strip club?
No.
Was there any point in time when you saw the defendant grab or throw any champagne bottles at any club? Okay. Was there any point in time where you saw the defendant have to be restrained inside of the strip club?
No.
And in fact, the only time that he came to your attention inside the strip club is when the decedent attacked him with the champagne bottle. Fair?
Yes.
There was never a point in time where my client attempted to retaliate inside the strip club, correct?
No.
There was never a point in time where he threw a weapon inside the strip club, correct? And there was never a point in time where you or anyone else had to physically separate him from the decedent. Is that correct? Thank you.
Can you redirect?
No, Judge.
Thank you, sir. You may step down. Oh, I do have a couple of questions for you. I'm sorry. You said that you actually didn't see the shooting, but that you felt something sort of whiz by your head. Is that right?
Yes.
Could you tell from what direction the shot came from?
No.
And just out of curiosity, who was the well-known rapper? Salve. Okay. I don't think that was relevant. I'm just noticing. You may step down.
Call Sergeant Ford. Can you call us back? Yes.
Sergeant Ford, you know the drill. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please have a seat. You get the spot. You may begin when you're ready.
Give us your full name, sir.
Sergeant Stephen Ford.
You can hold that microphone right on your lap if it's easier for you. And how were you employed?
City Detroit Police Department.
How long have you been so employed?
28 years.
And what is your current rank?
Sergeant.
And where are you assigned at this point?
Homicide.
Okay. Do you have a specific task within homicide?
Yes.
What is that task?
I extract video.
I'm sorry, say that again?
I extract video.
You extract video.
Yes.
I'm going to ask you if you recall an incident related to the Truth Gentlemen's Club at November 27th of 2022.
Yes.
And how did you extract video from that location?
Actually, we made the location and we actually took the video.
You actually took the entirety of the system?
Yes.
And did you download video from that system?
Yes.
And have you had a chance to review that video since the time that you downloaded it?
Yes.
And did you also take some stills or would you recognize stills taken from that video?
Yes.
Okay, I'm going to approach Judge. Okay.
Amen.
Proposed exhibit number 2.
recollection by looking through those, please? And do you recall those particular stills?
Yes.
And are those of people both inside and outside the Troop Gentlemen's Club on November 27th, 2022?
Yes.
I move to admit People's Proposed 2 in its entirety.
Any objection? Certainly not. All this stuff be coming in, Judge. All of it.
We just still have to go through the procedure.
All right, that's fine. Normally we stipulate the video, but
All right, so if there's a stipulation, it's fine. I'll receive the
Okay,
stipulation.
that's great. Then we're going to play the video next, Judge. Could you hand those photos to the judge, please? Thank you.
This is People's Proposed to be the core of the video of the shooting incident itself. I have it on separate discs, but the court needs to see it separately. Give me a second to share. This is, tell us, Sergeant Ford, what is this video that we're looking at right now? Oh, we're not seeing it. I'm sorry, Judge, it's the same problem as last week. It's on my screen. It's not popping up. Okay, quick record, what camera are we looking at? And is that the outside of the Two Gentlemen's Club?
Yes.
Okay, do you know which direction we're facing? Can you tell by looking at this?
No.
Is 8 Mile to the upper right of the screen?
Straight up front of the video.
All right. We're gonna start this video at 1:39:42, Judge. May have to run it a couple of times very fast.
All right.
Thank you. Judge, if you watch it on the laptop, it might be smoother, so we can see.
It's smooth on my,
So you're able to see it on, you need to see it again.
yes, please.
So let's start at about 1:40. And looking, of course, at the bottom center of the camera angle.
I recognize it from the still photos. Let's do it. Thank you.
And that is just the video that you downloaded from this particular location, is that correct?
Yes.
Thank you. I have some questions.
Councilman.
Good afternoon, Sergeant Ford.
Good afternoon.
Sergeant Ford, do you work in homicide currently?
Yes.
Okay. And you've been in homicide for an extended period of time, is that fair?
Yes.
And on this particular case, your role was to report to the scene and extract video, is that fair?
Yes.
Okay. Do you know how many hours of video you extracted?
So it was a DVR extraction, so because we took the hard drives, so I took it straight from the hard drives. So I probably have a half a day.
Okay.
Close to a day worth of video.
So that's at least 12 hours worth of video, is that fair?
Yeah.
Okay. And what do you do with the video after you get it? I mean, how does it go about getting transferred to being broken down into relevant parts? Can you tell the court about that?
So pretty much because I have so much video and we can't keep that much video, I have to sit down with the OIT to determine which parts we can keep and which parts we just put on storage.
Okay. Now, were there parts of this video that was placed on storage?
Actually, we don't have the capacity. I'm still waiting on some disk drives. We ran out of the larger disk drive, so it's actually still on my hard drive.
Let me ask a more direct question, because I believe your answer, I just want to make sure I'm clear. There's no video that was deemed to not be pertinent that's been destroyed. Is that fair?
Right.
Okay, so we still have all of the video. It's just that what we have, what Ms. Cooper and myself have, is what you and the officer in charge have determined to be important and relevant to the investigation. Is that fair?
Right.
And then once you and the officer in charge make the relevant portions from the investigation perspective, the prosecution makes that available via discovery. Is that fair?
Correct.
Thank you, Judge. Nothing further.
Thank you, sir. You may step in.
You have no further witnesses, Judge.
Any witnesses for the defense?
Not at this time.
Judge, you can move back over and I'll reserve record.
Please.
Judge, I'll be very brief. My objection will of course be that my client's actions were in an affirmative defense nature. That creates a question of fact. So there's not really a great argument to make here as to say that there's nothing for trial, other than from our perspective, we believe that he was attacked and there was a response, which I believe sets the stage for a trial.
Judge, you've seen the video, and you've seen the still photos taken from that video. This gentleman, I'm sure he was not being an angel at that particular location and was acting in a manner that was aggressive. However, after he punched the defendant in the face, he turned around and he walked away. He was shot in the back, and photographs clearly show that there was one shot, it was aimed at him, he was shot in the back, and that of course caused his ultimate death. So there are questions of fact in this case, Judge, but this is a murder 2, CCW, and felony firearm. I'd ask to find over on all counts.
Unfortunately, the complaining witness, it would appear to look for trouble and crime. That doesn't absolve the defendant, however, from his responsibility in this, and that he clearly intended to kill at the time that he pointed a loaded weapon at Stephen J. Beyond William Sticks and fired a shot into his back while the man was turned around. He at that time, as far as this court could see, posed no immediate threat to the defendant or danger to the defendant, yet the defendant shot him in the back. There may be some issues as to self-defense, but that's not for this court to determine. Court finds that people have met their burden of probable cause as it relates to the charges contained in this 1991. Court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant committed. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be March 2nd, 2023 at 9 o'clock a.m.
That's the direct line.
There was a DSU report order, they recommend no action.
So, Judge, what I'd like the court to consider, as it relates to as it relates to the defendant, in terms of how the actions, in terms of how the set of events took place on that particular day. Now, it's obvious, Judge, that there are things that will come into a court in the trial proceeding that I don't believe are appropriately admitted into a preliminary examination, but I do believe are appropriate for purposes of bond discussion. What we do know from the video that I do have, and of course I'm looking forward to getting the additional video evidence, is that we know that the decedent in this particular case was accompanied by a security staff that he had privately, and it was also assisted by security staff that was present at the particular location. And one of the reasons that I wanted to admit camera 11 into camera 23 into evidence is because you can see one of the security staff members pass the decedent a firearm immediately before my client shoots him. Now, it is true that the decedent may have punched my client in the face, but this is after an unprovoked attack. So this is after he's already hit him in the head with a champagne bottle. And I believe that the photographs are pretty clear, despite what the testimony was, that individual had a gun in his left hand. You know, now I can show the court the video. You can watch the security staff member immediately before the shooting pass the decedent firearm. And they do a quick, very quick hand to hand. And you can see in his left hand, he's holding a gun. So it is true that my client shot him, yes. But why did it happen? What are the totality of circumstances? And I would submit that when an individual has already attacked you with a weapon, was holding a deadly weapon, even if he's facing away from you, there's 1 second that took place between the strike and when the shot is fired. And it's easy, I always say this in terms of sports analogy, it's easy to watch a play unfold when we're sitting in the comfortability of our chairs, watching something happen. But in the immediacy, how did the defendant perceive the defense? Perceive the events? And that's what the self-defense instruction asks for. And I think that we're on very, very solid ground to be able to argue that when an individual who's already attacked you in an unprovoked fashion attacks you again and is in possession of a weapon, the deadly force at least could be reasonable. And if it's reasonable, then that means that his likelihood of potentially being exonerated is high. I'm not asking for a personal bond, Judge. I'm asking the court to set bond of $200,000 cash assured with house arrest, GPS tether. My client doesn't have any prior violent conviction. His entire family is here. He's retained counsel. And we know that he has a defense. This is not a premeditated killing. This is a heat of passion type of event where he's already been attacked. He's already been injured. We have photographs clearly depicting that his eye was opened up after this incident. And we'll be able to easily establish that the decedent in this particular case, who set all these events in motion, was armed with a weapon. For those reasons, I'm asking the court to grant my client a bond. Thank you.
I would strongly object to any bond reduction in this case. This is a person who shot somebody in the back, who had broken off whatever attack he had made. He's turning around and he's walking back into the bar with his shot. So there is no further aggression at that moment in time. You can't say that he's entitled to defend himself for some future event. The man is walking away. He's turned around. He's going back inside the bar. And that's when the shot is fired. Granted, that is within a short period of time. However, the choice that was made was that instantaneous choice to haul out a weapon and shoot somebody for punching them in the face. And I don't think that's at all appropriate for any sort of bond in this case. It should remain on you.
Judge, but that's a vacuum assessment, though. It's not just for punching him in the face, right? It's the totality of circumstances. You already attacked me with a dangerous weapon. I'm already injured. You attack me again and you're armed. So it's not just, hey, you punch somebody in the face and then they pull a gun and shoot you. If it was, I would be seated. We would have left already. I wouldn't still be talking. What's irrefutable is that the person who already attacked you for the second time in an unprovoked fashion is armed with a dangerous weapon and accompanied by armed security. So I'm just supposed to assume that even though that you've already attacked me twice in unprovoked fashion, that you're finished because your back is temporarily turned? That's not a safe assumption. And again, I'm just asking, Judge, that he get a high bond, that he not sit in jail for an indefinite time until we try this case next year. And Ms. Cooper has to convince 12 people that they should disregard the fact that the individual who's deceased in this case is a violent, aggressive member of the community who attacked him for no reason.
You'll note that the defendant walked away, calm as you please, after shooting somebody in the back. He walked through that parking lot, he walked up to 8 Mile, and he absented himself from the jurisdiction of this court until very recently. So I would again say that there are questions about this young man coming back to court. I think that for the safety of the community, based on the actions that we see in photos and in video, we should not be granted one of these.
Pretrial services did a rather extensive background investigation on the defendant. And although they recognize he doesn't have a capious history, that none of his convictions or contacts appear to be assaultive in nature, I do know that many of them involve weapons, carrying concealed weapons, receiving concealed stolen property, one of which gang squad, narcotics, and special crimes unit was involved. And I believe there was some testimony, or at least a question that was posed regarding some gang activity. There all this gives the court some concern as to what's really going on here. Now, I understand what happened, that for whatever reason, the decedent hit the defendant with a champagne bottle or something along those lines. And I'm not saying that the decedent is a choir boy or anything like that. However, the video I saw was there was some kind of skirmish that took place, spilled outside. The defendant was struck, looked like a lancing blow. Person turned and walked back inside the strip club, and the defendant pulls out a gun, aims it, and shoots the decedent in the back. Then walks away and kind of walking like with security, like he's part of the security team. Maybe he was at some point in time, I don't know. But in any event, I am going to err on the side of caution that pretrial services recommends no action. Prosecution is recommending no action. I have a decedent that was shot in the back that was caught on video, even though the decedent may have been the initial aggressor in all of this. At the time that he was shot, he was not an aggressor. In fact, he was walking away from it. For those reasons, the court is going to continue to find agreement. For the protection of the community. Have your exhibits. These are your exhibits.
Oh, yeah.
Yeah, I know that was Thank you.
Yeah.
All right, Judge. Take it easy.
Okay, you too. Be safe.
I'm gonna go 1:30 now.
1:30. Yes.
And I'm. It just. Okay. That's okay. And so that's is it? Oh, that was, because I asked about that. I think it was solicitation. You know. Yeah. She's not, she's on vacation, so. This week. Thank you. Okay. All right.
Hello there.
Good morning, Judge.
Good morning. Good
Or afternoon, I'm sorry.
How many witnesses do you have?
Just one, Judge. Meeting on the 17th. Not used to this new phone. I know.
So you're talking about, right?
She said she had to say.
How you doing, Watch? All right, Judge. Okay.
It's, this is the, did they do this one? Or is it Kadar? Is she a prosecutor or defensive prosecutor?
That would be the.
Oh, it is? Okay, I thought Kadar was a prosecutor too.
This is a different one. Could be a different.
Yeah, but that's attorney.
Okay. Hey, also Spencer, just colleague. Can you have Godwin Edith sent up? To 234. Thank you.
Good afternoon. How are you? Good. Good. Good to see you. What's up? Yeah. Thank you.
The other. Well, that's the other. She is. Yeah. And then that's the issue. I just. So. Right.
Screenshots.
number. Yeah, so it's totally. He's been in, remember, $1 million home. The guy is, I never. Oh, what was he, never saw a bag. This happened. I didn't do nothing here. I mean, he's from Nigeria. He's a permanent resident. He's has no record whatsoever. He got school there too. That's when you are a bunch of problems. So. I know, but this is on here.
Protect you, but I can show you, this is what we don't know is real or not. So the text messages I really heard. There's like probably ghost spam type of situation. So here's
So straight. That one.
here are the text messages.
Also, criminal rights. It's got a rap sheet. He's escaped from prison.
Well, if you just want to be.
This man.
Did you get me a copy too?
Yeah. You should, Mark called him the master of all masters. He sued the Macomb County jails. I mean, he's unreal. Even after I came, we might be friends with my plan, asked me how I go. They told me, let me get you some money, let me get some that. Then I hear it. He says, give me some money. You know what I mean? And then he says, they want to find out how, what was the strong points of the case.
So, Judge,
I took screenshots, like I said.
and this is something that
No, she, actually, she. In my opinion, that's what I saw. Realized right away. Other than this big, I'm sure. She ain't here. Right, but what it is spray these really cans. They did to this point. They're investigating the two. He got somehow police to his girlfriend's house for an hour to visit. And Betty police said that the officers were so, they couldn't believe the order, so they thought it had to be true. Say, take this, make the whole seat. And then we do this. Figure out that.
That's my biggest fear.
It was like a more interesting job I like to see.
No, I wouldn't say what I said the last time. You know why I am. When I told you this is what it appeared to me, I couldn't swear to
That's
it.
why I said it so early. I've been looking forward to this.
Yeah.
You ready, Your Honor?
Yes. Two, three, 55353 for the state of Michigan versus Godwin O'Con, edit. Defendant is charged with count 1 homicide, solicitation of murder, count 2 extortion, count 3 extortion, count 4 criminal sexual conduct, 33 force or urge, count 5 witnesses bribing, intimidating, interfering in criminal case punishable by more than 10 years.
Good afternoon, Your Honor. Grace Berger, appearing on behalf of the people, P-80298.
Good afternoon, Your Honor. Mark Hyder, 235-143, on behalf of Godwin Edith, Your Honor.
All right, today is the date time set for preliminary examination. Are we ready to proceed?
We are not, Your Honor. Our complaining witness has failed to show.
Your Honor, I move to dismiss.
Your Honor, the people would ask for an adjournment. These are serious charges. I believe that we will be dismissing count 1, 2, 3, and 5. However, the people feel that we could proceed with count 4. I did speak to the victim yesterday. She was on board. I have no reason to believe that she wouldn't show today. However, she has not picked up her phone, and I have not seen her in the courthouse.
Ms. Broden, as you know and understand and appreciate, this court can only adjourn for a good cause. I haven't necessarily heard good cause, other than she's not here. That doesn't give me good cause to adjourn the matter. Unless we have some other information that someone has prevented her from coming, or threatened her to come, or something along those lines, and I might maintain such a motion. Anything short of that, I haven't heard good cause. The court is inclined to dismiss this matter without prejudice.
Thank you, Judge.
Thank you, Your Honor.
The court will dismiss this matter without prejudice.
Thank you, Your
Now,
Honor.
let me also, Mr. Edit, sir, you should be very thankful. You have a very good attorney that you have working on your behalf, and you have a reasonable prosecuting attorney as well that can see through a lot of things. Do not, I repeat, do not make things hard on yourself by trying to contact a complaining witness in any form or fashion. Stay away from her and anyone connected to her. Watch your back, okay? Thank you very much. All right.
Okay.
Great, sir.
Thank you very much, Judge.
Thank you. Under the dismissal, Mr. Hader.
Your Honor.
Thank you, sir. Dismissal order.
I'll fill one out, Judge. Yeah. Can I speak to him first, Your Honor? Okay. Thanks a lot.
Ms. Dixon in the house.
Good, how are you?
All right. Hey, how's it going, man? You doing okay?
The office of Perkins, they want to know, are you anticipating signing it? They must have talked to you about that. He has an exam that, so, you don't remember that? Okay. Second point. I think that day that I wasn't, I think you did.
Have a seat, somebody gonna come and get you up there. Here you go, mister.
That's their main.
Who you want to have? The judge. Mr. Henry, I want you to get you.
That's the main witness. That's just Wayne County.
So is this a picture of thing? That's it?
On my way tonight. She's on Facebook, so I'm not, and I know you're big on it. Hope you should. Yeah. Yeah, I remember what it was. Oh, mine. Okay. Okay. You good? Well, that's awesome. I had a.
Did you?
I think I'm trying. All right, good seeing you.
Okay, good seeing you.
All right.
Take it responding.
That's it for today. Nice to meet you. Thank you.
40 years, and you see no
Okay, you too. docket for today.
I got to set it on the floor. Got to set it on the floor. And this one.
Yeah, I got it. You need that? Oh, okay.